The next state to pass wholesale regulation is Maryland. And just like with recent laws passed in other states, the focus in Maryland is on disclosure, but Maryland took a little bit different approach. On this video, I'm going to tell you everything you need to know, including specific written disclosures so you can stay compliant. All that and more coming up.
For a limited time, you can get a free copy of Jerry Norton's Wholesaler Contract Pack with all the contracts you need to flip houses without risk. Claim your free copy at wholesalercontracts.com.
My name is Jerry Norton. I'm the wholesale industry's leading authority on all things regulation. I maintain a free report with all of the different regulations by state. You can download that for free at wholesaleregulations.com. This new law in Maryland is a combination of Senate Bill 160 and House Bill 124. This new regulation became effective October 1st, 2025. Like most regulations, Maryland first defines what a wholesaler is, and Maryland decided that a wholesaler has two different roles. First, you have a wholesale buyer, which is a person that enters into a contract of sale with an owner of an owner-occupied residential property in order to assign the contract to another person for a monetary assignment fee. Okay, now a few things here. Notice the law limits the definition to just owner-occupied properties. That means if the seller is not living in the home as their primary residence, it's not considered wholesaling and the law doesn't apply. Now, more on that in a minute. The other thing that I want you to notice is it only says it applies when doing an assignment. So there's no mention of doing a double closing. Now you'll see why that matters in a minute, so keep watching. The second role of a wholesaler is defined as a wholesale seller. Now this time the law describes two different scenarios that define a wholesale seller. It says a wholesale seller is a person that, without holding legal title to owner-occupied residential property, one assigns the person's beneficial interest in the property to another. Okay, that makes sense. Doing the assignment, that matches the definition of a wholesale buyer. But then there is a second scenario in the definition of a wholesale seller. It says, without holding legal title, enters into a contract of sale for the property. Well, that is exactly what happens with a double closing. Think about it. A wholesaler in a double closing does not hold title at the time he enters the BC contract with the end buyer. That means a double closing fits the definition of a wholesale seller. By the way, that would also include a novation because you don't hold legal title at the time of contracting a novation. Okay, so let me summarize this for you. If the property is owner occupied and you intend to do a traditional assignment, you are both a wholesale buyer and a wholesale seller. But if you do a double closing or a novation, you are not a wholesale buyer, but you are a wholesale seller. Now, this is just ridiculous. I mean, couldn't they find someone in Maryland with some common sense to figure out an easier way to define wholesaling? I mean, it's not that complicated. I would have been more than willing to help them come up with a very simple, very clear definition for a nominal fee, of course. So now that the definition of wholesaling is clear as mud, what does the law mandate that you can and can't do? Well, similar to Ohio, Oklahoma, Pennsylvania, and several other states, Maryland is only concerned with disclosure, which, by the way, is a complete 180 from their previous position. Just a few years ago, Maryland proposed House Bill 0301, which sought to require wholesalers get licensed and had nothing to do with disclosure. But that bill was withdrawn and never passed. So back to the disclosure. As of October 1st, 2025, on owner-occupied properties, Maryland requires both wholesale buyer and wholesale seller to disclose your intent to wholesale and what interest you hold. Now, this disclosure must be made before entering into the contract, and it must be in writing, and it must be clear and conspicuous. Now, there are some really good things here if you compare this disclosure to other states like Ohio or Oklahoma. For example, it does not need to be a separate document. It can be a paragraph in your contract. Also, there is no requirement to seek legal counsel. There's no requirement to explain your assignment fee or your intent to make a profit. And there's no requirement to explain you do or don't hold professional licenses. Now, I have all of these things already in my contract anyway, because I'd rather over-disclose and be safe than sorry, but you do you. I'm just explaining the requirements for this new law. In fact, after Maryland's new law, I met with my attorney and we decided to add some additional language about conveyance in my assignment agreement and my BC contract when I do double closings. So let me review these changes with you and then tell you how to get my latest updated versions of my wholesale contracts for free. First, in my AB contract or my purchase and sale agreement with sellers, here is my assignment disclosure. The seller acknowledges that buyer may assign his or her interest in the purchase of the property to a third party end buyer who shall be any party selected at any time by the buyer prior to close of escrow and affirmed with a separate written assignment of agreement executed by buyer and end buyer. Seller acknowledges that buyer will collect a fee from end buyer that is separate from the agreement, and this part is what I just updated, and does not change any of the buyer or seller's rights or obligations under this agreement. And I thought that was important because the seller needs to know that if I do an assignment, it doesn't affect or impact the original contract with them. They get everything agreed upon in that contract. Next, in my assignment agreement, I added this paragraph. Buyer of contract, assignee, is advised that contract holder, assignor, only holds an equitable or contractual interest in the property and may not be able to convey legal or marketable title to the property. Now, I always just assume that the end buyer understood that since it's an assignment of contract, but I like that it's very clear now in writing in my assignment. I want that language as a general statement with all of my buyers, not just Maryland. And then finally, in my BC contract, when I do double closings, I added a similar paragraph about conveyance. In paragraph 12, it now reads, seller holds only an equitable or contractual interest in the property arising from a separate contract of sale with the current owner of record. Seller may not be able to convey legal or marketable title to the property unless and until seller acquires such title. Now here I think this disclosure is really important because it could be unclear to the end buyer that you're wholesaling in a BC contract. Now, like I said, I routinely update my wholesale contracts and I'll give these latest updated versions to you for free. Just go to wholesalecontracts.com to download those now. And just in case you're wondering, if you fail to provide proper disclosure to sellers in Maryland, as I described, the seller can pull out of the deal before closing without penalty. And if you fail to provide proper disclosure to the buyer or assignee, he can also back out before closing and get his earnest money back. And like I said, my contracts, if you use them, they'll meet the requirements of Maryland. But even if you're not in Maryland or not required by law, I highly recommend that you still fully disclose. In Maryland, you're only required to disclose if it's a primary resident. So if the seller is not living in the home, the wholesaler doesn't have to disclose he's wholesaling. Now, when I talk to sellers, I always ask if it's vacant or if it's occupied and if the seller is living in the home. So this is easy to know. However, I've said this before and I'll say it again. It's always better to disclose whether you have to or not and whether you're required by law or not. If done correctly, it builds trust because you're being honest and transparent, and it helps create proper expectations in the event that you need to extend closing or renegotiate the price. Now, I recently did a live seller call. I explained to the seller that my intent was to wholesale her property and she had no problem and we locked up the deal. So watch that video now and see what it looks like to explain to a seller, and I'll see you on the next video.